Hi, and welcome to our next installment of bite-sized videos on IP. I'm joined as ever by John Pryor of Exalt IP. Hi, John.
David, hi. Pleased to see you again.
Hi there. So we've talked a number of times on previous videos about the importance of IP. But the reality is for SMEs, the patenting process is not an easy one. It's complex, it's long, and most importantly, it's very expensive. So I thought it'd be useful to delve into patents to see why they can add value, but also to see if there's any alternatives. Certainly if businesses are wary of investing significant amounts of funds into the process. So first question is, what is a patent, and in your mind, what are the biggest advantages of going down that route?
Yeah, so a patent is some sort of legal statute that covers an invention and essentially grants you 20 years monopolistic rights over that invention. So in order for something to be patentable, it has to be inventive, it has to be novel, it has to be useful, and it has to be non-obvious. So Dyson's cyclonic vacuum cleaner back in the day, many years ago now, I suppose, was all of the above. It was new, it was inventive, it was non-obvious, and it was useful. And it was a step forward in the cleaning game, of which we're not too familiar ourselves, David. But yes, it answered all the questions. So, and from Dyson's perspective, it actually worked out really well for them because, you know, they sold their concept to many different vacuum clean manufacturers, and none of them said it was going to work. In fact, Hoover said wouldn't work, and then immediately went off and copied it, and they were able to use their patent to actually win that case. Now, you know, there's a bit of history behind that, of course, and you know, if they had had insurance, it might have been easier for them, but it certainly cost them a lot of money to take on Hoover. So, you know, it is a right. It doesn't. It gives you. It stops you. It enables you to stop other people from using your invention. It doesn't necessarily provide you the rights to practice that invention, and many people find that slightly confusing. So it's more. It's known as a negative right. It stops others from using your invention. You do need to do some clearance searching to make sure that you have the right to use that invention in the marketplace, but that's a separate question. So that's what a patent is. And your other point was, what are the advantages?
Yeah. Given the cost and the length of time it takes to obtain, it's good to understand actually what you get in return.
Yeah, I mean, clearly there's that ability to defend from others utilizing your invention there. But, you know, it ticks many boxes. The investors in your business generally are going to be pretty pleased if you're able to show them you've got a granted patent protecting their investment, protecting your invention. So, you know, there's more to the story than just that. But in many cases, the investors are going to be sufficiently pleased, and it's going to be a tick in the box. It shows that there's some defense, some concentric castle walls around the invention, a crown and crown jewels that's going to give them that sort of security and confidence that their investment's going to be safer with you. It's potentially, you know, it gives you 20 years rights over that invention, in which time, if somebody wanted to use your invention, you've got every right to charge them a toll or a rent or what's known as a license fee for utilizing that invention, exactly the same way as if you were to rent out a room in your house, you could charge somebody to use that. So, and then there might be tax advantages in the UK patent box, for example, and in other countries with innovation boxes. If you are using and selling a product in the marketplace with a patent, then you can claim some tax benefits from that. But as you said, David, it's an expensive undertaking. It's time consuming in terms of, you know, there's some toing and froing, but it generally takes a while to get a granted patent certainly over many different territories, and that's where the expense comes in. So it depends where you want to sell and market your products but if you want to go for several countries, it can take many years to get them granted in all different jurisdictions. So there's a cost undertaking connected to that and a time undertaking. So what are your alternatives? Well, if your cyclonic bagless vacuum cleaner was going to be determined, you know, somebody else was likely to invent it in the near future, somebody skilled in the art, without, you know, getting any leaked information about your secrets there, was likely to independently invent it, you're probably much better off patenting it. But if you feel that you've got such a step forward and nobody else is going to know this for a while, trade secret, for example, is protecting, but pro quo, the reason government granted you that 20-year monopolistic right is because you're sharing that invention with the world. Yeah. And that's there's benefit analysis for you to undertake internally within the business. What are the benefits? What are the advantages? What are the disadvantages of sharing this with the world at this stage? And how much do we have to share? And how much can we retain and keep a secret? And so those are really good questions to ask, David. Sorry, I've talked a lot there. Over to you.
This is all interesting stuff. So before you start the patenting processes, from what you've said, there's a number of questions that you need to ask yourself about the business and about the innovation. One, what's the likelihood of it being copied? And in what time frame might that happen? Now, clearly, cost is a significant factor, certainly for SMEs. So, as the alternative is kind of a trade secret regime, can you talk a bit about that and how that could work as a complete alternative, or do you see it more as a kind of a parallel protection alongside patents?
It's a good question. I don't think it's an and or. I think in reality they work superbly well in conjunction. But it depends on your marketplace, and it really depends on your business objectives. And these are fundamental questions to ask, because not every patent is created equal, and there are different reasons for having a patent. It might just be to get the tax advantages. It might just be to get the ticking the box from the investor. It might be that you want to exclude the competition. It might be that you want to license it, and this will inform slightly different strategies for pursuing that patent. And that's a really important consideration to have and a discussion to have with your intellectual property advisor and ultimately your patent attorney. It's not that straightforward. And to some extent, people might say, David, and this comes back to your business, is it worth pursuing it depends on your object. Is it worth actually going through the process and the expenditure and the time to get the patent if you don't have the will and the resources to defend it or assert it? And these are really important questions to ask before you undertake the process. It's my bugbear, if I may, is that people just think that's the obvious, the logical next step route, without considering the alternatives, and probably without just considering all the other things that they could do around about that invention. Copyrights and designs might have some benefit in terms of protection. Another alternative strategy, different strategy, leaning out the other way, is publication. If you publish that invention, it prevents others from gaining monopolistic rights over it. It's a free-for-all. Everybody can use it, of course, as you can, but it also means that other people can't assert that right against you. It's available for everybody. So there are different ways and means, and it's a consideration. But very, very closely linked to the business and the objectives that the business wants to achieve with this patent, and where it's going in the future.
Yeah, no, I think that's really helpful, because I think there's a trap that businesses can fall into, that they have, if they're innovative and they've come up with something that's novel, that they feel that they have to go down the patenting route. But actually, there's a number of questions you need to ask before you decide what the best thing for your business is. And I think that's a very good lesson, and I think we'll wrap it up there. But thank you for your time. As ever, if you've got any questions on topics we've covered, please do get in touch with John at Exalt IP. He'll be happy to answer any queries you've got. So thank you, John. Until the next time.
Great stuff. Thank you very much, David.
Okay.
Thank you.
Cheers.
Speak soon.